Hello and welcome to the 2017 Litigation Update webinar. My name is Bailey Reeves and I will be in the background answering any Adobe Connect technical questions. If you experience technical difficulties within the Adobe Connect session, please use the Q&A box on the right-hand side of your screen and our technical assistance team will help in any way possible. If you are having issues hearing over the phone, you may press *0 and an operator will assist you. Please note that as an attendee, you are part of a larger audience. However, to maintain privacy, the number and names of attendees will not be displayed. All attendees will be in a listen-only mode throughout the presentation, and as a reminder, today's call is being recorded. We will be holding a Q&A session at the conclusion of today's presentation. To submit a question, click on the Q&A panel located on the lower right-hand side of your screen. Type your question into the text field and hit send. This seminar is accredited for 1 hour of Illinois' MCLE credit. Please inquire if you wish to seek CLE accreditation in additional states. During the webinar, we will be providing 3 CLE codes. Please write these down. We will be mailing evaluation forms at the end of the webinar and will ask for these codes. If you have any questions regarding CLE, please contact cle@brinksgilson.com. With that, we invite you to sit back, relax, and enjoy today's presentation. I would now like to introduce your moderator for today, Mark Remus. Mark, you now have the floor.
Thank you, Bailey, and welcome everyone to the 2017 Litigation Update webinar for Brinks. I'm Mark Remus. I'm co-chair of the Litigation Practice Group at Brinks, and I'm happy to be moderating today's panel discussion. I think we have a number of interesting topics that are ripe for discussion in the litigation context for 2017. We've got 4 presenters today. First, David Lindner is going to start off with a discussion of recent developments that concern willfulness case law post-HALO and how it impacts defending willfulness allegations in litigation in this day and age. We're then going to turn to 2 related presentations from Jim Cleland and Alex Fernandez on a very hot topic these days, and that is venue. Jim will give a quick summary of where we are with respect to venue challenges post-TC Heartland. And then Alex is going to focus in particular on a promising venue, and that is the Middle District of Florida. Finally, the 4th presenter today is Andrew McElligott, and he's going to update us on recent developments at the Patent Trial and Appeal Board. With that, I'll turn it over to David. Thank you.
Thanks, Mark, and welcome everyone. I second Mark's comments about a great panel that we have today. And I'd like to just jump right into it with the role of opinions of counsel post-HALO. Just to give you a brief idea of where we're going to go with this, I'm going to start with a brief overview of the state of law of willfulness pre-HALO, a little bit of discussion on the HALO decision itself, some lessons learned from post-HALO cases, and then some suggestions of going forward and how we can protect against willfulness and how to treat opinions. So pre-HALO, we were operating under the Seagate standard, which was the 2-part test. We're all probably very familiar with that. There was the objective reckless prong and the subjective knowledge prong. Under this test, patent owner had to prove both prongs by clear and convincing evidence for the district court to even have the discretion to assess enhanced damages. The objective prong was evaluated by the record of evidence that was developed during the infringement proceedings. And this was pretty relevant because even if the defenses were unsuccessful or defendants didn't even contemplate a defense at the time of infringement activity, as long as there was a substantial question of validity or non-infringement proved at the trial phase, then the objective prong would fail and willfulness would fail. So this was a pretty high bar, and I think what we started to see after Seagate and kind of through its case law was a rather large decrease in the number of opinions that were being requested as a result of the difficulty of trying to overcome this objectively reckless prong. So with that in mind, we then turn to HALO, and the Supreme Court rejects that Seagate test. Part of the issue that the Supreme Court had with this was that objective recklessness prong was required in every single case before a district court could consider enhanced damages. And this was problematic because egregious conduct could be shown by bad faith alone. In other words, under the Seagate test, you could exclude the intentional infringer, that person or company that had no doubt about a patent's validity and didn't even have any thought about a defense to infringement at the time of the infringing activity, and that was quite problematic to the Supreme Court in that it was eliminating the possibility of enhanced damages for this egregious behavior. The other big outcome that came out of HALO was the standard by which willfulness was proved. Contrary to the Seagate decision, where it was by clear and convincing evidence, Supreme Court tells us that willfulness only needs to be proved by preponderance of the evidence. So where do we look to for guidance on egregious infringement? Well, the court tells us that we have a long history of guidance, and we can look to that case law going back almost 150 years. The cases predominantly have treated the innocent infringer different than the willful and wanton infringer. And one of the key points that comes out of this is Justice Breyer's concurrence that you need something more than just knowledge of the patent in order to be deemed a willful infringer. There has to be some additional bad act, bad faith that's been going on here. But a key point is that we're now going to measure the accused infringer's conduct at the time of infringement. So no longer can we, for the first time, present a defense at the trial phase. We're going to start to look at what's happening prior to litigation. Some additional guidance on how to measure egregiousness comes from, and the court directs us to, the Reed factors. There's a little bit of overlap here between willfulness and enhanced damages, and I really think that the Reed factors are dealing more with enhanced damages. The second factor, though, does address what I believe is opinion of counsel, whether the infringer was aware of the other party's patent protection, investigated the scope of that patent, and formed a good faith basis. We'll see in the cases that I'm about to discuss, there's this constant pull back and forth between willfulness and egregiousness, and enhanced damages. And just because somebody may be found to have willfully infringed doesn't necessarily mean that enhanced damages are always warranted. So with that in mind, let's look to a couple of cases. And as you can tell by the title of the next couple slides, timing is going to become very prevalent in this. In the Dominion Resources case, it was undisputed that defendant was aware of the patented technology prior to developing its own product. Additionally, defendant had knowledge of Dominion's patent once it had issued. Nonetheless, even though they had knowledge of the technology as it was pending and the issued patent, they continued to work on their potentially infringing product and never obtained opinion of counsel. They continued this also without obtaining any insight from somebody that was familiar with reading of patent claims. And so again, as we started to see now here with this timing, this is really where the court came down on this decision. There was a willfulness determination by the jury that was actually decided under the Seagate standard, but when the court went back to review it for enhanced damages, the court applied the HALO analysis and didn't find that the more lenient standard in HALO changed anything. Prevalent here was that defendant knew about the issued patent and started working with its customer a month after learning about the patent. and continued this for almost 18 months, the entire time aware that there was possible patent infringement, but yet took no action to try and clear this through any type of opinion. The next case that kind of follows very similar to this is Arctic Cat v. Bombardier Recreation Products. Again, this is a situation where defendant had knowledge about the patents. They actually knew about them before they issued. They had a patent agent provide a cursory one-sentence review, an opinion about the patents, but problematic here was that that patent agent reviewed the pending claims and not the claims that were actually issued. So again, we run into another situation here where there was no opinion from non-infringement, and the only opinion of counsel that was provided on invalidity was based on art that was previously before the patent office. What I do think is interesting in these two cases is we start to see willfulness is going to the jury. And as a result of that, you want to make sure that your opinions are competent and that they are timely obtained. If we look to the next case, which is Great Batch v. AVX, again, very similar situation to the prior two. Defendant knew about the patents prior to the initiation of litigation. What was different here is that they actually obtained opinion of counsel. Summary judgment granted for a finding of no willfulness in this instance. Additionally, defendant, even in this case, made some attempts to design around the patents. And I think that's pretty relevant here because what we learned from this is even if you have a product that's on the market and maybe you get notice of potential infringement, there's a possibility to design around that patent even after the fact and obtain an opinion on that design around. It may not limit enhanced damages in their entirety, but it could cut off the amount of that enhancement. Just another quick summary here. Trustee of Boston University, again, outside counsel provided an opinion of non-infringement before the initiation of the lawsuit, and so again, finding of no enhancement. Jury did find willfulness, and this is again the pull and tug, I think, between the Reed factors, but again, the court found while there was a jury determination of willfulness, there was no enhancement of damages was warranted. The last case that I have today is Omega Patents v. Cal Amp. I included this in for the recognition that you need to make sure you have a good faith basis in your opinions, even if you obtain them prior to the initiation of a lawsuit. There's a couple of different issues that were going on here, and I'll let everybody read the bullet points even when the slides get distributed after the fact. But a key point here is that defendant had a representative, their representative testified at trial that he previously received an oral opinion of non-infringement prior to the initiation of litigation, but didn't have it reduced to writing. As we all know, reliance on opinion comes with waiving of privilege, and there may be communications that are produced in conjunction with that. And that's exactly what happened here. The problem was that emails from that same representative that said he had received the oral opinion indicated that 8 months after the litigation was initiated, he was making suggestions to opinion counsel as to the non-infringement position. The court had a very big issue with this and did not find either the representative or opinion counsel's testimony to be believable as a result, a finding of willfulness and enhanced damages. So I know we've covered a lot here, but what can we take from this? A couple takeaways are there's really no hard and fast rules in opinions going forward, but if there's a close decision, you should be looking towards obtaining an opinion and timely obtaining that opinion in advance of any type of litigation. As I mentioned before, if you've already got a commercial product on the market, consider designing around and obtaining an opinion on that design around. As we know, opinions cost money, so there's going to need to be an evaluation. You may not need to get an opinion on every single product. If it's a clear-cut case and there is in-house legal department, they may be able to render a non-infringement position on that. But if it starts becoming a critical patent, a critical product, or credible threat from a third party, that's when you definitely want to consider getting some type of opinion from outside counsel. And lastly, the last bullet point there, I note that this is becoming more and more important in due diligence and acquisitions of companies. If you're going to acquire companies, consider if they have done any type of searching, if they've received any threats, and what type of activity they've already taken to investigate those threats, because that may be your problem that you're going to need to address if you do follow up and acquire that company. So with that, I will turn it back to Mark.
Thank you, David. That was an excellent summary. I appreciate that. And just to note for the group that we will be taking questions, but holding them till the end of all four presentations. So we may circle back with David to ask any follow-up questions on willfulness. Right now, we need to provide one of the three CLE codes. The first code is timing, T-I-M-I-N-G. So that's the first code. We will now turn to the next presentation where Jim Cleland is going to bring us up to speed on the recent events concerning TC Heartland and patent venue. So I'll turn it over to you, Jim.
Thank you, Mark, and good afternoon, everybody. Since the Federal Circuit's VE Holdings versus Johnson Gas appliance case in 1990, district courts have interpreted the term resides in the patent venue statute to mean wherever a defendant is simply subject to personal jurisdiction. And what we've seen is that interpretation has allowed patent plaintiffs to bring patent suits in virtually any jurisdiction where patent defendants have made sales. In the recent TC Heartland versus Kraft Foods case, the Supreme Court reversed the Federal Circuit's VE Holdings decision, relied heavily on the prior Forco Glass versus Transmira case from 1957, and concluded that as applied to domestic corporations, resides in the patent venue statute refers only to the state of incorporation. The legal side of TC Heartland has been debated in the news and the press extensively over the course of the past 3 weeks since the May 22nd decision by the Supreme Court. But I want to focus on the practical impact of the decision, both on what happens with new patent lawsuits and what happens with pending patent lawsuits. First, we'll focus on the new patent lawsuits. And because the Supreme Court's decision was limited to domestic companies, we really have to look at both domestic companies and foreign corporations. On the domestic side, venue now boils down to two options. It's proper in either a defendant's place of incorporation or where the defendant has committed acts of infringement and has a regular and established place of business. Now, the Supreme Court did not specifically address foreign corporations in TC Heartland, but in general, the Federal Circuit's prior decision in Princeton Digital from 2012 is still controls, and that says that foreign defendants are subject to the general venue statute and can still be sued in any federal court where they are subject to personal jurisdiction. So what will be the next battlefront on venue? It's fairly straightforward in most instances to determine where a corporation's actually incorporated, but the Supreme Court didn't really say a whole lot on the second prong of the test in terms of what constitutes a regular and established place of business. You have to go back to the Federal Circuit's In re Cordis case from 1985 to start getting some clues as to what that means. This is really the only Federal Circuit case before VE Holdings that addressed the issue, and in that particular case, venue was sufficient in Minnesota because in that case, the defendant employed 2 salespeople who worked from home and kept inventory in their houses. Most jurisdictions find that a permanent physical location is sufficient to meet this test, but as this prong becomes more important in venue fights and venue challenges, patent litigators will face a couple of key questions. Is a permanent physical location or a brick and mortar actually required? Are exclusive sales representatives living in a jurisdiction enough? Is a mere distribution center sufficient? What if that distribution center is shared by several different companies? There are a lot of different permutations that we're going to see play out over the course of the next several years. Another tricky question is what happens when the state of incorporation has multiple jurisdictions. Many states have multiple districts: Texas, New York, California, Illinois, Michigan, Florida, etc. And there's really no Federal Circuit precedent here. Courts have gone both ways on this issue. Some have determined that venue is appropriate in any district in the state of incorporation. Others have found venue appropriate only in the district where the principal place of business is located. This issue, I believe, will really depend on the regional law of the jurisdiction. So if you encounter this scenario, you really have to look at what's happening locally. The next question is, where will new patent lawsuits be filed? Unified Patents, a group that some of you may be familiar with, they're made up of about 60 patent owners who try to combat non-practicing entity litigation, performed a study on patent venue. They predicted that 1,000 cases may move out of the Eastern District of Texas, that Delaware is likely to handle approximately 500 more cases per year, and there seems to be agreement on the increase in patent filings in Delaware pretty much across the board, no matter who you listen to. But what we wanted to look at is what are some of the other predictors of where new patent cases will be filed. Well, the first place you probably look is the top patent jurisdictions over the course of the past several years. If you can't file in Texas, where else are cases being filed? The location of Fortune 100 companies may be important. Those companies tend to be involved in lawsuits many times. And of course, the place of incorporation of those Fortune 1000 and other large companies, because again, they're the ones who are targeted. So what are the top patent litigation districts? We took a look at this for the past 5 years. The last 5 years is when Texas has really asserted its dominance as the top patent district. And again, starting with the premise that venue will no longer be valid in the Eastern District of Texas for many cases that are traditionally filed there, many by non-practicing entities, you can see that most of those cases are probably going to move to other popular districts. This is a graph of the top 15 litigation districts over the past 5 years, and you can see that while the Eastern District is dominated with twice as many cases as compared to this next closest competitor, Delaware is by far and away a clear second. But then you kind of roll into other popular venues that are likely to see an increase. Number 3 is the Central District of California. You've got the Northern District of California, New Jersey, the Northern District of Illinois, the Southern District of Florida, the Southern District of New York, down to the Middle District of Florida and the Eastern District of Michigan. So outside of the large increases that are expected in Delaware, we're likely to see increases in those other districts that have a relatively even distribution as we move on out. And while the Supreme Court did not necessarily address policy in its T.C. Heartland decision, there were many amici that chimed in with the view that forum shopping in patent cases was becoming a serious problem. This pie chart demonstrates why, and is another visual that just shows how much the Eastern District of Texas has dominated patent litigation filings in the last 5 years. In fact, one judge in the Eastern District of Texas, Judge Gilstrap, had about 25% of all patent cases filed in the U.S. this last year. There are many out there that believe such an unequal distribution is really unhealthy for patent jurisprudence. And while certainly the Eastern District of Texas won't fall off the map going forward, things are going to change. And we've seen these trends play out so far. This is a graph of the top 20 districts in which patent cases have been filed in the U.S. since T.C. Heartland through last Friday, June 9th. The number one observation is that Delaware is clearly surging to the top, and there were another 14 cases filed in Delaware yesterday. Number two is that Texas is still alive. It's the second most popular venue. But other jurisdictions like the Northern District of California, the Northern District of Illinois, the Central District of California are right there with Texas, and you see a fairly even distribution after that amongst numbers 6 through 20. So we're already starting to see some of this redistribution of patent cases. But is Texas dead? And why are we still seeing cases there? I think we will. I think we will see cases because, number one, foreign corporations can still be sued there, and number two, large national chains or corporations that may not be headquartered in Texas may still have stores or facilities there, you know, an Apple, Best Buy, Culver's. That might still leave them on the hook. Moving to the next potential predictor of future cases, a lot of large corporations are obviously incorporated in Delaware. We did not focus on that, but we looked at where are these large corporations actually located? Where are they headquartered? Where are their main facilities? We looked at the Fortune 1000 companies, and what you see across, when you look at all 50 states, is that there are really no big surprises. California, Illinois, New York, Texas, Ohio, and Pennsylvania represent some of those larger blue spikes. But there's other states that might creep up. Some of the ones that I haven't mentioned are Georgia, Massachusetts, and even Virginia. We might see increases in those states. This is, again, a pie chart that shows the distribution, and unlike the pie chart we saw earlier where Texas and Delaware took up about half of that pie chart, this is a much more even distribution, which we should start seeing probably a little bit more of an even distribution of cases. So what to expect? Delaware will take the top spot. Other popular states of incorporation will see increases in all likelihood. We'll see distribution in currently popular cases. But it raises issues concerning multi-district litigation. You might have to go to more than one location to enforce a patent. That might result in increased expense to enforce patents, and possibly the increased use of consolidation through MDL, where a panel of judges decides whether or not to consolidate multiple cases in multiple jurisdictions in a single jurisdiction based upon factors such as convenience and fairness. We, of course, still have foreign corporations, and then are we going to see an MPE shift? Are we going to see that litigation shift to different forums that might be friendly to patentees? Or are we going to see it even ship out of the country? There's some prognosticators suggesting that Germany may be a new target. And finally, we'll go through pending cases with my last two slides. This is going to be another battleground. And unfortunately, there's probably more questions than answers here right now. We're likely to see a wave of venue challenges. We know that. We've already seen some of those challenges take place. And they're going to take place in Texas prominently, but probably in other locations as well. We'll see litigation over the question of patent waiver. We'll see a question very related as to what's the law that applied at the time of the waiver. Has there been an intervening change in the law? Will judges allow defendants to amend their answers to erase improper venue under this new law, or will they hold their feet to the fire under the law that existed at the time they answered the complaint? We'll likely see some venue discovery, both now in existing cases as well as at the beginning of new cases, akin to the discovery that is present when personal jurisdiction is disputed. And some district courts are dealing with the issue of which law applies to prior venue selection. Some courts say, hey, it's the Federal Circuit's V.E. Holdings law. Another court has said, no, the right law at the time was the Forco Glass case from the Supreme Court. V.E. Holdings was never good law. You messed up if you ever tried to rely on V.E. Holdings. And finally, we have to ask ourselves, are there other procedural moves that we should be considering? We may see patent plaintiffs with pending suits file suits in other jurisdictions with proper venue before their current cases are dismissed. Likewise, we may see patent defendants in the middle of patent suits file motions to dismiss and declaratory judgment actions in other favorable jurisdictions with proper venue. Well, time will tell what trends might actually emerge here. It's safe to say that we should all, when we're in pending cases, evaluate all procedural options moving forward, because we're just not sure how this landscape is going to change. And with that, I'll pass the baton on. Thank you.
Thank you, Jim. That was an excellent presentation. I'll now turn the floor over to Alex Fernandez, who's going to talk more specifically about the Middle District of Florida. Alex?
Thanks, Mark. So Middle District of Florida, just fair warning as a beginning to the presentation, this is not an especially esoteric or abstract subject matter that's going to take a huge amount of focus. These are straightforward issues, but hopefully you leave the presentation with a deep desire to file a patent infringement action in the Middle District of Florida. So the goals are that they all stem from this idea that the Middle District of Florida has quietly become a significantly favorable jurisdiction to patent owners, and there's some tangible and intangible reasons for this, and my goals are to unpack those reasons for the strong reputation that Florida carries as a patentee favorable jurisdiction, introduce you to the Middle District of Florida, and really explain why the reputation is likely to endure and even improve over the coming years. So let me provide a prompt introduction and background to the Middle District of Florida. The district is enormous. There's 4 divisions in it. It includes Jacksonville up in the orange, Orlando in the blue, Tampa in the yellow, and the Fort Myers division way down south. In terms of the populations of these areas, it's incredibly diverse. It spans from the Space Coast on the East Coast, which is really a burgeoning private sector in aviation, avionics, and aerospace. Even after NASA has declined, the private sector has stepped in. So companies like SpaceX and Lockheed Martin, Bombardier, all have a presence on the northeast coast. And in addition to that, there's what we'll affectionately refer to as a retirement belt. There's an enormous number of retired folks in the central part of the state and all the way down to Fort Myers. Of course, we have the tourism epicenter of Orlando and those West Coast beaches from Clearwater to Fort Myers. And a lot of people, apart from citrus, they overlook that Florida has a very large agricultural presence. So between all of those aspects, there's a great diversity in the types of the companies and individuals that are residing in Florida. By far, Tampa is the largest division out of all 4 divisions. It includes 6 active judges. 4 of those judges are women and 2 are men. And let's drill down a little bit into the numbers that tell us why it is that Florida is so patentee favorable. These are based on the PricewaterhouseCoopers study from 2017. It's a perennial study that is oftentimes pretty closely followed for indications of where different districts lie. It ranks the top 15 districts on a number of different factors. In this study, the overall rank for Florida is 6th across all those factors, and the patentee success rate and the speed are probably the 2 factors that are most notable in Florida. Looking at the Florida success rate, right now in 2017, the percentage was 50%. So we're looking at pretty much a cool coin toss. If you file a patent infringement action in the Middle District of Florida, and that doesn't sound particularly comforting until you consider that the overall success rate is 33% across all 15 of the districts. And kind of in front and behind us are Texas. The Eastern District is number 1, and the Northern District is number 3 in terms of success rate for patentees. After that is Delaware. But once you get to Delaware, there's a 9% drop in the success rate, and it drops precipitously after that. So it's a significant difference. And it provides a significant benefit to, at least percentage-wise, to file in the Middle District of Florida. The speed, the median time to trial for filing in Middle District of Florida is 1.9 years. That's ticked up by a month or 2 over the last year, and we don't expect that it's going to exceed 2 years. That's really a factor of the local rules here, which call for a track that's 2 years long in all but the most complex cases, and most patent cases fall into a normal 2-year track. And then once you get involved in the case, typically the push and pull is the defendants want to delay, and they're pushing out towards 2 years, and the plaintiffs want to advance the case, but they oftentimes will meet somewhere in the middle, if not at 1.7, 1.8 years. So why isn't Florida even more popular as a destination? That is the median damages award. At this point, the median damages award for patent infringement actions in the Middle District is about $500,000, and that is frankly tiny compared to its brethren jurisdictions in Delaware, Virginia, and Texas, which are all over $15 million. And that may well be changing over the last couple of years. There's been significant increases, and these results are based on 20 years of data. So it's difficult to see even dramatic change over 1 to 2 years. But we've seen some fairly large verdicts over the last year. Now, I'd like to address a few of the qualitative benefits of the Middle District of Florida. It has an extraordinarily strong bench. The judges here are quite sophisticated. They want to get it right when it comes to IP, and a number of them have been known to take a specific interest in IP cases and patent cases in particular. They have gone so far as to attend multi-day boot camps to help educate them on the latest trial aspects and litigation aspects of patents. The judges in the Middle District of Florida are very diligent. The Middle District is one of the most heavily burdened districts in the United States. The judges here have more than 600 weighted case filings per judge. So weighted case filings takes into account the nature of the case, and within that metric, the average in the United States per district is 483 weighted case filings for each judge. So the judges in Florida have nearly 200 more weighted case filings than judges in other districts. And there's some districts in the United States that have as few as half of the caseload that these Middle District of Florida judges carry. And even so, these judges still generally manage to stay on track to have patent cases resolved within a couple of years. It's also a diverse bench. 4 out of the 6 active judges, as I mentioned earlier, are women, and 2 of those are African American women, and 1 is a Hispanic woman. So extraordinarily diverse bench, and going to the point that these judges are highly interested in getting it right when it comes to patent issues. We've frequently encountered clerks that have that are patent attorneys and that come from patent firms or IP firms and have experience in that area. So it's clear that these judges are making calculated decisions to reach out to and get qualified clerks that will help them in making the right call on the patent side. Another qualitative benefit of the Middle District of Florida is that it has a strong IP bar. We have an IP board certification program. It's one of the only states in the nation with an IP board certification. So this is what the courthouse in the Middle District of Florida looks like in Tampa. It's a modern building built in '98. What isn't readily apparent from this is that it's really fast to get in and out of it. We've got a speedy security, and this is located pretty close to our offices and the airport. On to more substantive issues. There's bound to be some changes in the Middle District of Florida over the next 5 years. We're hoping, and it appears that there's going to be an addition of 6 new judgeships spread throughout the Middle District of Florida. The Florida Senators Nelson and Rubio included very recently a bipartisan request for these 6 new judgeships, and that would help significantly cut the load on these judges. The docket is likely to hold steady around 1.8 to 1.9 years for cases. This is for the reasons I mentioned earlier as far as the local rules and how they govern the management of a case. And I would also anticipate that there's going to be continued growth in ease of access to Tampa Bay area. The airport is currently undergoing a $500 million improvement and expansion. So all those things in order to the benefit of litigants here. There's also the possibility of transferred cases from the Eastern District of Texas, as Jim noted earlier, and given the expansive geography of the Middle District of Florida, many companies are bound to have a presence, some sort of brick and mortar presence between Jacksonville, Orlando, Tampa, Fort Myers, Naples, and a number of other cities in the Middle District of Florida. With that, I'll turn it back to the moderator, Mark.
Thank you, Alex. That was very interesting. We'll next turn to the topic of recent developments at the PTAB by Andrew McElligott. Oh, I need to mention the second CLE code is Heartland. Drew?
Thank you, Mark. Good afternoon, everyone. Well, a large focus of today has been on venue. So it seems fitting to talk about the Patent Trial and Appeal Board, or PTAB, next, which is now the most popular venue overall. Today we're going to focus on first the recent statistics showcasing the popularity of the PTAB, and then some statistics that perhaps explain some of the reasons for that popularity. Then we'll touch on the Patent Office's procedural reform initiative, which it announced this past April. And we'll cap things off with a quick look at the big breaking news from this past Monday, the Supreme Court's grant of cert in the Oil States v. Green Energy case regarding the constitutionality of AIA reviews. Because what better way to end a presentation than by questioning the relevance of everything you've just said. Sorry, there's the agenda. First things first, the rise of post-grant proceedings, such as IPRs and re-exams. In retrospect, I should have put the continuing rise of post-grant proceedings here because I don't think it's news that we're continuing to see more post-grant proceedings, but I do think it's interesting to note that we haven't seen a hint of the ceiling yet or a leveling off. To kind of show you what I mean by that and provide a bit of context, this next slide shows the number of appeals from the USPTO that were docketed at the Federal Circuit each year since 1997. So you can see from this that in the last couple of years we've seen a sharp increase in the number of appeals from the Patent Office in comparison to the district courts. In fact, in 2016, the number of appeals from the USPTO exceeded those from the district courts for the first time ever. And this is a trend that we've continued to see in 2017, with at least, as of April, 113 more appeals from the Patent Office than from the district court. So as I mentioned, and as the steep purple line on this graph suggests, we have yet to hit the apex here for just how busy the PTAB is going to get. In fact, this past quarter, the PTAB received a record-setting 561 petitions, higher than any quarter to date. And on that note, let's take a look at some of those most recent statistics from the Patent Office and see why its popularity continues to rise. Now, a lot of commentators have taken issue with the manner in which the PTAB calculates its statistics and institution rates. I'm not looking to resolve those disputes today. I'm just looking to discuss the most recent numbers that they've floated. I'll let others call foul on them. So these numbers come from a recent keynote address given by Michelle Lee, the director of the USPTO, from about a month ago. Director Lee broke down the most recent numbers into a waterfall graph to show the fate of every one of the 6,700 petitions that have been filed between September 2012 and March 2017. The chart shows us all the different fates that could befall a post-grant proceeding, from settlement to a request for adverse judgment. But I want to focus on two particular areas that show the institution rate and the percentage of claims held unpatentable in a final written decision. So the area of the graph we're looking at first is right at the divide between red on the left and blue on the right. The two bars on either side of this divide show us the number of petitions that have made it all the way to an institution decision. For those new to post-grant proceedings, the first hurdle you need to clear is institution, where the PTAB looks at your petition to decide whether you've met the threshold standard, whether it be raising a substantial new question of patentability in the case of a petition for re-exam, or in the context of inter partes review, whether you've shown a reasonable likelihood that you would prevail in challenging at least one claim. We can see from the graph that of those approximately 4,800 petitions that have made it to an institution decision, 70%, or that 3,382, have been granted, and 30%, or that 1,469, have been denied. So that's a 70-30 split in favor of instituting. Traveling further down the waterfall to the very end, we see those patents that make it all the way to a final written decision. According to these numbers, as the PTAB is reporting, 66% of petitions have found all of the challenged claims invalid, while 17% of petitions have held some of the challenged claims invalid. So if petitioners make it all the way to a final written decision, they stand an 83% chance of being successful on at least some of the claims they've challenged. Now, I've heard different percentages based on different analyses, some quoting an institution rate as high as 80% and a 90% chance of succeeding in holding the claims invalid. But whether you're looking at 70 or 80 for institution or 80 or 90 for percent being held invalid, there still exists a strong incentive on the part of those seeking to challenge the validity of a patent to do so at the PTAB, which explains the meteoric rise we've seen in the number of filings. As we move on to the next slide, keep in mind this 70-30 split on institution, because you have to remember that in the context of this particular waterfall graph, we're talking about averages over a 5-year period. So this next graph shows us what that looks like over the 5-year period. We can see it broken down over the lifetime of the AIA. As you see, as the number of petitions have been growing, the institution rate has actually been declining. This may be due to a number of factors, from the quality of the petitions being filed. As we just saw, it's a very attractive venue for people to file at. So the quality of the petitions, ones that people maybe before would not have brought in the form of a petition and would have just made their case in the district court, are now being brought there because of those statistics and the favorable nature of the process. Outside of that, another possibility for this decrease in institution rate is that the PTAB may be trying to course correct. It may be a reaction by the PTAB to the rise in number of people filing and them in response raising their bar for institution and how much of a showing a petitioner needs to make in order to meet the threshold standard for institution. There isn't too much that we can really conclude right now from this, but it's an interesting statistic to keep an eye on and see particularly if that percentage is stabilizing, actually leveling off there. Seems to be mid-60s, maybe even lowering a little bit towards just 60%, but doing so at a very slow rate. Moving on to our next item, we have the Patent Office's Procedural Reform Initiative. Because you can bet the second after the Patent Office puts a system in place, there will be opinionated commentators just detailing all of the different ways that it needs to be changed. Well, the Patent Office has been more than willing to listen to those commentators, and it announced in April that it was starting a procedural reform initiative to investigate some of the issues that have been raised with respect to the AIA proceedings. As we just saw with the statistics, the Patent Office will soon have 5 years' worth of data to examine from the AIA reviews. And so now is as good a time as any to use that information and experience to improve the proceedings. As an example, you can see listed here in the first bullet point that the first sub-bullet point, that the PTAB is looking into the issue of multiple petitions. Patent owners have raised this as a concern because currently petitioners are allowed to file as many petitions against a patent as they like, without a limit as to how many are asserted against one particular patent. And without a limit, some petitioners could abuse the system potentially by filing dozens of petitions. At least that's the argument that patent owners are raising. In response to these concerns, the PTAB actually conducted a study and is in the process of wrapping that up. And they collected data showing that the large majority of patents, about 68%, are really only challenged via a single petition, and another 20% are only challenged via 2 petitions. So 88% are challenged by 2 or less. Now, there are patents that are challenged with 5, 6, 7, and yes, sometimes more than 7 petitions, but these are only accounting for 3.5% of the total petitions. So although there is perhaps some smoke here, there may not be the kind of fire that would require any kind of drastic change to the proceedings or for the PTAB to put a hard limit on the number of petitions that a petitioner could file. With respect to that second bullet point, I do just want to mention that in addition to the PTAB looking at motions to amend, which currently hold a 5% success rate at the PTAB, the Federal Circuit is also looking at this, and we're awaiting a decision in the In-Re Aqua Products case, which should come down. That was an en banc hearing, and it should come down pretty much any day now. The court is expected to rule on whether the burden of proof applicable to motions to amend during an IPR should fall on the patent owner or should it fall on the petitioner. In other words, when the patent owner moves to amend a claim, is the burden on the patent owner to show that that new claim is patentable, or is it on the petitioner to prove that it's actually unpatentable? I'm sure we'll be issuing a client alert on that case when it issues, so keep your eyes peeled for that. Moving on to our last topic. So far we've discussed the popularity of the Patent Office as a venue for challenging validity and why it continues to be so, and the Patent Office's plan to improve or refine those proceedings. So now we get to take a look at the Supreme Court calling the whole system into question. The big news from this past Monday was the Supreme Court granting cert in the Oil States case on the issue of whether or not the AIA proceedings are constitutional. The crux of the issue here is whether or not patent rights are public property rights or are private property rights, because if they are private property rights, they can only be revoked by an Article III court, while in contrast, if they are public property rights, they can be revoked by a government agency, like the Patent Office. Now, the Federal Circuit previously ruled on this issue in 2015, and it said that patent rights are public property rights, and because Congress has the right to delegate disputes over public rights to administrative agencies, AIA proceedings are therefore constitutional. The Federal Circuit also noted in that decision that Congress had the authority to delegate to the Patent Office the power to issue patents, so it would be kind of odd if Congress could not also authorize the Patent Office to reconsider its own decisions. At odds with the 2015 Federal Circuit case are a handful of Supreme Court cases from the 1800s, which declared that patent rights are private property rights, and that the only authority capable of invalidating those rights is vested in the courts. So we've got 120 to 150-year-old precedent from the Supreme Court versus 2-year-old precedent from the Federal Circuit, with a whole lot of congressional intervention, like the passage of Congress's 1980 reexamination statutes and 2011's AIA in between that. This is a lot for the Supreme Court to consider, but it's important to note that, as the second to last bullet point here indicates, the Supreme Court has previously rejected petitions raising this kind of constitutional challenge. In comparing this case to those that the court had passed on before, it's unclear why they've decided to take this particular case up for review, except perhaps for the recent rise in discussion at the Federal Circuit regarding the uncertainty of exactly where the line is between public and private rights with respect to patent rights. Given the Supreme Court's previous decision to pass on hearing it, I think it's unlikely that this spells any kind of doom for the future of post-grant proceedings, but it's still important to keep it in mind should you choose to file a petition at the PTAB or as a patent owner if you should get pulled into a post-grant proceeding. The Supreme Court will likely hear arguments on this case this winter and issue a decision in June 2018. So, quick fun fact, in inter partes reviews, a final written determination by the board is issued within 1 year. So those receiving a decision granting institution today on something like an IPR may receive a final determination from the board on the same day the Supreme Court determines whether or not that IPR was constitutional. With that, I will turn it back over to our moderator, Mark.
Thank you, Drew. That was a very helpful summary of where we stand with the PTAB. And that concludes our substantive presentations for today. The final CLE code, code number 3, is petitions. And to summarize, the 3 CLE codes for today's presentation are timing, Heartland, and petitions. I want to thank everyone for joining us today and thank the presenters in particular. If anyone has any follow-up questions, please feel free to follow up with the presenters, and we will be distributing copies of the presentation after we're concluded today. Thank you.